may sit in council seats next to the accused or
Thank you. Wishes to sit on council. Mr. Van der Daal, you may sit down for the time.
Lord, first and foremost, I fulfill my instructions of being the archivist from the DAR here with my learned colleague, Mr. Combrink, and instructed the court attorneys from Stellenbosch. If I understand correctly, some members of the press wish to sit where counsel normally sit. My concern is only that I've made a mistake instruction again for my client. May I ask you, your lordship's indulgence, would it be possible for my client to take a seat directly behind me? That might alleviate the matter.
Mr. Van der Daal, you come forward and sit behind your counsel. The press are under no circumstances to record any discussions between Mr. Breda and his legal team and the accused.
prior to
So does that mean now that the press is sitting accused?
Looks like it. I quite like it.
may please for the law also prior to commencing with the formal proceedings, Lord, I've been instructed to put on record that it is the contention of the National Director of Public Prosecutions in regard to the application brought by Visa 24 that the Lordship's order is suspended in terms of the provisions of Section 18, subsection 1 and or 2 of the Superior Courts Act. In view of the leave to appeal brought by both the NDPP and Mr. Van der Daal pending before the Supreme Court of Appeal, but that as we are of the view that the SCA will be dealing with the matter as a matter of urgency, and so as not to impede the commencement of the trial, we have agreed to the amendment of the order as per Breda 24's letter written to your lordship. As neither the state nor the accused objected to the plea explanations being broadcast to recording, and that after the plea explanation order will be further suspended.
Thank you very much, Mr. Allen. Let's make that very clear to the press. There will be proceedings up to the stage and including the stage of the plea statement. After that, when the evidence of the first witness is laid, the candidates will have to stop recording until we hear from the Supreme Court of Appeal. Is that understood, Mr. Butler?
Yes, I would very your lordship's convenience and just read out what I understand your lordship to have directed. So the media
Yes, Mr. Butler, we now in triple proceedings. We're not part of this proceeding.
No, I'm just
wanting to know whether
yes, my lord, exactly so. So the lordship has directed that the plea explanation may be broadcast. After the plea explanation, the witness will be led. No broadcasting of that witness's testimony is allowed. Your lordship intends to permit an inspection to be conducted at which
the inspection will the press can be present.
at which the media may be present. I understand from counsel for the prosecution and for the defence that the report of the inspection will be placed on record on Wednesday. I assume that the media may be present during that as well. And then proceedings will adjourn until next week.
Doctor, I prefer you not taking these proceedings any further.
Yes, I just place on record for the media to advise.
I can't place anything on the because they're not criminal proceedings. They're not outside that is privy to criminal proceedings other than the defense and prosecution.
Naturally, my lord.
Butler, I'm very sorry to interrupt you.
As your lordship.
But we've taken account of what you said, it correctly reports the order and
Yes, but I just place on record media to advise your lordship during that.
Thank you very much. Thank you very much. Now, let me just say at the outset, it's going to be a long and difficult trial. I trust that we should have the cooperation of the press throughout this proceeding. Notice there's a large contingent of press present. And in the sense historic that the entire trial may or may not be broadcast. But if you misconduct yourselves in any way, if you prejudice what could be the future of criminal trials conducted in the future. So I trust that I shall have your cooperation in this. Mr. Good. Sorry, Mrs. Gallagher.
This Lord Mayor then proceed with the charges to the court.
Before you proceed with the charges, the charge contemplates the minimum sentence. Is your client aware of that?
I'm sorry, I didn't hear you.
The charge contemplates the minimum sentence.
Yes, he's aware of it.
Is he aware of that?
He's aware of it.
Not necessarily to the
Not necessarily. Those are charges of course 1 to 3.
1 to 3.
Yes.
Thank you very much, Mr. President. Mr. Evans.
And for this, that the accused is guilty of the crimes of murder, count 1, count 2 murder, count 3 murder, count 4 attempted murder, and count 5 defeating or obstructing the administration of justice. In that the accused was about Tuesday, 27 January 2015, and at or near 12 Foster Street, the Zalsa Winelands Golf Estate in the district of Stellenbosch, unlawfully and intentionally count 1, killed Rudy van Breda, an adult male, by hitting him repeatedly with an axe or similar sharp object, and or inflicting other violence unknown to the state. Count 2, killed Martin van Breda, an adult male, by hitting him repeatedly with an axe or similar sharp object, and or inflicting other violence unknown to the state. Count 3, killed Teresa Jacoba van Breda, an adult female, by hitting her repeatedly with an axe or similar sharp object, and or inflicting other violence unknown to the state. Count 4, attempted to kill Marie van Breda, a female who was 16 years of age, by hitting her repeatedly with an axe or similar sharp object, and or inflicting other violence unknown to the state. And further, that the provisions of Act 105 of 1997 are applicable in that counts 1 to 3 the offences are specified in Part 1 of Schedule 2 of the said Act, in that the murder was planned and premeditated, and that a minimum sentence of life imprisonment is applicable. Count 5, it is used with the intent to defeat or obstruct the cause of justice, committed an act or acts to wit inflicting injuries to his person and or tampering with the crime scene and or supplying false information to the police in order to mislead the police as to the true identity of the perpetrator, which act or acts defeated or obstructed the administration of justice. The penalty to which is in terms of provision 276 of Act 51 of 1977 in the discretion of the court. Those are the charges.
Mr. Van Breda, how do you plead to count 1 as indicated by the prosecuting counsel? Count 1 relates to the murder of the adult male Rudy van Breda. Count 2, the murder of the adult male Martin van Breda. Count 3, the murder of Teresa Jacoba van Breda. Count 4, the attempted murder of Martin van Breda. Count 5, the attempt to defeat himself the cause of justice. Rather than noted to plea of not guilty, is so all the counts. Mr. Donald.
Please, Lord, Mr. Van der Daas, please, according to these instructions to us, we have prepared a written plea explanation. I beg leave to hand up a copy to your lordship and the learned assessor, as well as to my learned colleagues.
Thank you. That's good.
I hand a copy to my client as well, please.
Yes, of course.
Shall I read it into the record, Lord?
Please do. Thank you, Mr. Lord.
I'm the accused in this matter. I understand the charges against me and plead thereto as follows. At count 1, I plead not guilty to this charge of murder. I further refer to the contents of paragraph 6 to 65 below. At count 2, I plead not guilty to this charge of murder. I further refer to the contents of paragraphs 6 to 65 below. At count 3, I plead not guilty to the charge of murder. I further refer to paragraph 6 to 65 below. At count 4, I plead not guilty to this charge of attempted murder. I further refer to the contents of paragraphs 6 to 65 below. At count 5, I plead not guilty to this charge of defeating or obstructing the administration of justice. I further refer to the contents of paragraph 6 to 65 below. General averments, introduction. The averments contained hereunder are made to explain why I plead not guilty to the charges against me. It is a summary of the events that occurred at our home as best as I can recall, and not meant to be a detailed account of everything that took place, as well as a brief, relevant family history. Background and family history. My father, Martin van Breda, date of birth 5 August 1960, married my mother, Teresa Jacobus van Breda, near the Toy, date of birth 19 June 1959, on 16 February 1990. My oldest brother, Rudy, was born on 10 July 1992. Subsequently, 2 further children were born from their union. I was born on 1 November 1994, and my sister, Marlene, on 12 October 1998. All 3 of us were born in Pretoria. I commenced my schooling at Woodhill College, Pretoria, during January 2001. In the beginning of 2006, our family immigrated to Perth, Australia. Here I was enrolled as a grade 6 learner at the Loreto Primary School. In 2007, I transferred to Scotch College, where I eventually matriculated in 2012. In 2011, Rudy took up his tertiary studies at the University of Melbourne, studying mechanical engineering, and in 2013, I enrolled at the same university to study physics. During that year, our family moved from Perth to Goodham. During January 2014, my parents and Marley moved back to South Africa, where they initially resided in Gordons Bay. Rudy and I accompanied them, but we only stayed in South Africa for the University of Breda, whereafter we returned to Melbourne, Australia. My parents and Marley's relocation occurred principally because my father had launched a new school project in South Africa, which he labelled EduGrow. This venture had grown and was increasingly demanding his full and undivided attention. In addition, my mother missed her family and she yearned to be closer to them. At that juncture, Rudy and I remained in Melbourne as we were still busy with our respective studies. In 2014, my parents enrolled Marley at Somerset College. During about March 2014, my parents and Marley moved from Gordons Bay to 12 Gosper Street, Dissolved Winelands Estate. Towards the middle of 2014, I temporarily halted my studies at the University of Melbourne with a view of taking the gap year. Subsequently, in August 2014, I also moved to Dissolved where I joined my parents and Marley. Exhibit K, the Lord's Leave, document entitled Emissions in Terms of Section 220 of Act 51 of 1977. I'm the accused in the above mentioned matter, and although I do not have personal knowledge of all the facts referred to hereunder, I have satisfied myself with the existence of these facts and am prepared to make the following admissions. Post-mortem examinations are identity of the deceased. 1. That the deceased in count 1 was at all material times correctly identified as Rudy van Breda, after referred to as Rudy. That Dr. Daphne Anthony, thereafter referred to as Dr. Anthony, conducted a post-mortem on the body of Rudy on 29 January 2015. 3. That the body of Rudy suffered no further injuries from the time that it was found in our bedroom at 12 Gosper Street, Dissolved Winelands Estate on the morning of 27 January 2015, up to the time that the aforementioned post-mortem was conducted. 4. That Dr. Anthony noted her findings on the post-mortem report number WC/12/0034/2015, marked as Exhibit L, brackets, it is not admitted that all these findings are correct. 1.5. That the cause of Rudy's death was a head injury and the consequences thereof, and therefore unnatural. 6. That the deceased in count 2 was all material times correctly identified as Martin van Breda, not referred to as Martin. That Dr. Anthony conducted a post-mortem on the body of Martin on 29 January 2015. 8. That the body of Martin suffered no further injuries from the time that it was found in Mine Rudy's bedroom at 12 Goscar Street, Dissolve, Wynand Estate, on the morning of 27 January 2015, up to the time that the aforesaid post-mortem was conducted. 9. That Dr. Anthony noted the findings of the post-mortem report number WC/12/0003/2015 marked as Exhibit M. 10. That the cause of Martin's death was head injury and consequences thereof, and therefore natural. 11. That the deceased in count 3 was all material times correctly identified as Teresa Jacoba van Breda, hereinafter referred to as Teresa. 12. That Dr. Anthony conducted the post-mortem on the body of Teresa on 29 January 2015. 13. That the body of Teresa suffered no further injuries from the time that it was found outside Mine Rudy's bedroom at 12 Goscar Street, Dissolve, Wynand Estate, on the morning of 27 January 2015, up to the time that the aforesaid post-mortem was conducted. 14. That Dr. Anthony noted the findings on the post-mortem report number WC/12/0032/2015 marked as Exhibit N. 15. That the cause of Teresa's death was head injury and consequences thereof and therefore natural. Then collection for material for forensic examinations. Paragraph 16. That on 8 April 2015, Dr. Plea collected a hair sample from my biological sister Madly van der Laan, hereinafter referred to as Madly, and sealed the sample in the forensic evidence bag with the seal number as indicated. I'm not going to read out all the seal numbers every time. Whereafter the aforesaid forensic evidence bag was handed to Constable Zuko Matu, hereinafter referred to as Constable Matu, who booked it into the SAP 13 Breda Stellenbosch Police Station under the reference number as indicated. 17. That Constable Martin took the forensic evidence bag with the intact seal number as indicated out from the SAP 13 Breda Stellenbosch Police Station with the reference number given on 10 April 2010 to send it to the Forensic Science Laboratory, and after referred to as the FSL. That on 27 January 2015, Dr. G. Potgieter at Medical in Stellenbosch collected a fingernail cutting and fingernail swabs from Muddy, which was placed in the PSA-EC kit with seal number as indicated. That on 18 March 2015, Dr. H.A. van Zyl collected a hair sample from me and sealed the sample in the forensic bag with seal number as indicated. Whereafter the aforesaid forensic evidence bag was handed to Constable Martin, who booked it into the SAP 13 registered at Stellenbosch Police Station under the reference number as indicated, whereafter he booked it out again to transport it to FSL Victoria. On 20 March 2015, Constable Martin delivered the sealed forensic bag with the seal number as indicated to the FSL Victoria under the reference number as indicated. 20. That on 27 January 2015, Dr. L.G. Albertson, here now referred to as Dr. Albertson, took a bottle swab from me, which was placed in the evidence bag and sealed with seal number as indicated. Whereafter the aforesaid sealed evidence bag was handed to Sergeant Stephen Adams, here now referred to Sergeant Adams. 21. That on 27 January 2015, Dr. Albertson also took 3 swabs from my hands, which were respectively marked by her number given R. Hunt, Dame Aria, number given R. Hunt, and number given L. Hunt, and which were then placed in 3 separate sealed holders with the reference number as indicated. The aforesaid sealed holders were then placed in an evidence bag and sealed with seal number as indicated, whereafter the aforesaid sealed evidence bag was handed to Sergeant Adams. That on 27 January 2015, Dr. M. van Zyl took a blood sample for me that was sealed with seal number as indicated. The aforesaid sealed blood sample was then handed to Sergeant Adams on 27 January 2015. On 10 May 2015, the aforesaid blood sample was analysed at the Forensic Chemistry Laboratory, Cape Town, by means of methods which require skill in chemistry, which obtained the following results. no drugs could be detected in the blood specimen. 23. That on 27 January 2017, Major F. J. LaRue confiscated the following items of clothing worn by me at the scene at 12 Gosford Street, Disaster Estate, Stellenbosch. A pair of grey shorts, which was placed in a forensic evidence bag and sealed with seal number as indicated. 2. A pair of white socks, which were placed in a forensic evidence bag and sealed with seal number as indicated. That on 29 January 2015, during the post-mortem examination, Dr. Anthony took a blood sample and fingernail scrapings from Rudy. The blood sample was sealed with seal number as indicated and placed in a forensic evidence bag with seal number as indicated. The fingernail scrapings were sealed with seal number as indicated, and the sealed blood sample and the nail scrapings were then handed to Constable Martin on 29 January 2015. That on 29 January, during the post-mortem examination, Dr. Anthony took a blood sample with fingernail scrapings from Martin. The blood sample was sealed with seal number as indicated and placed in the forensic evidence bag with seal number as indicated. The fingernail scraping was sealed with seal number as indicated. The sealed blood sample and the nail scraping were then handed to Constable Martin on 29 January 2015. 26. That on 29 January 2015, during the post-mortem examination, Dr. Anthony took a blood sample and fingernail scraping from Teresa. The blood sample was sealed with seal number as indicated and placed in the forensic evidence bag with seal number as indicated. The fingernail scraping was sealed with seal number as indicated. The sealed blood sample and nail scraping were then handed to Constable Martin on 29 January 2015. Then on 12 February 2015, Dr. Anthony took hair samples from 3 bodies, respectively marked WC12/0032-2015, WC12/0033/2015, and WC12/0034/2015 at Upbrook Funeral Home in Belgium, whereafter she handed the samples to Constable Apollos. I consent to the above admissions being reported as formal admissions in terms of Section 220 of the Criminal Procedure Act and 51 of 1977, the meaning and legal consequences of which have been explained to me by my legal representatives. Again, the Lord was signed this morning in my presence by my client, and I can confirm that I have explained the provision of Section 220 for him. Certainly.
You've heard what the advocate has read out. It's done with your comments. You support what he says. Thank you, Mr. Chairman.
That this being the admissions document software accepted by your Lordship as Exhibit K, as we've already marked it, and your Lordship will notice that we've annexed the 3 post-mortem reports that refer to respectively marked Exhibits L, M, and N with your Lordship's leave.
Thank you very much, Mr.
Court, please.